Good morning, everybody. We want to thank the HKTDC for the opportunity to come here today to talk to you about intellectual property. Intellectual property, of course, is now today on everybody's minds. And it is important because people follow the money, basically. In America, for example, assets in private hands is approximately $55 to $60 trillion. And the recent survey shows that as of 2009, already that part was not showing. In 2005, out of that 55 or 60 trillion dollars, which mostly is real estate, 5.5 trillion was intellectual property, intangible properties. And by the time it was 2011, the number already went up to $9 trillion. And what is intellectual property? It is anything that is intangible that basically distinguish your products and services from that of the competition. It gives your products and services a uniqueness so that perhaps you could sell it for a higher price. And it's probably one of the most valuable business asset, especially for new businesses. Made in China has been such an important term for Greater China and for Hong Kong in the last few decades. But when you think of made, it has to be more than just manufacturing. It really is MA for manufacturing and DE for design. And the trend is that the value is constantly shifting from manufacturing to design. So why do you want to understand IP? IP for most businesses means added value. And for businessmen, you have to avoid infringement, so you have to know what to look out for, what claims other people may bring. And it's a way for the businessman to capture value in the business. And for most businesses, and also for trade associations, you have to know enough as to when you need to bring in help, such as talk to the lawyers. And a very important part is that for any business to grow, for a business association such as the TDC to help its members, to help the industry, you have to incorporate intellectual property in the planning. So, next please. Today's presentation, first we're going to address the different types of IP, and then we're going to segue into the US intellectual property culture, because you have to understand the culture to make effective use of the IP. And we'll also talk about related general issues related to IP. Our first speaker of the day on the substance is Mr. Jeffrey Sheldon. Jeffrey is the founding attorney of our firm, Sheldon, Mack & Anderson. He was the ex-president of the State Bar IP section and well-noted author, for example, of How to Write a Patent Application, which is the training handbook for most of the new patent lawyers in America. With that, Jeffrey.
Okay. Thanks for coming, and good morning to you all. The starting point under U.S. law is anything can be copied. So if you see a product out there or a service out there, anybody can do it. with some exceptions, and that's what we're talking about today, exceptions. And I'm going to talk about patents, but the other exceptions are trademarks and copyrights, trade secrets, contract agreements. Danton will take care of everything but the patent side. So next one. So the reason I show you this product, it's a Tizio lamp. Maybe you've seen it. I think it's in New York in a museum there. We had a client who made one that looked like that and got sued, so we became familiar with it. But what's interesting is you look at that and you think, you know, what's protectable about it? Well, this product, according to the other side, had a utility patent on it, so I'll be talking about patents. Also had a design patent, and that's another type of patent we'll talk about. Claimed they had trademark rights in the appearance, and that's actually what we got sued on, and arguably has a copyright. And maybe in the manufacturing process had trade secrets. So the takeaway point here is there's a lot of ways, if you have a product or a business, to skin the cat. A lot of ways to protect things. And this one product is an example of that. Had about 4 different ways. Let's see, Danton brought some stuff. This one. Here's another example. Now, one of the more stupid ideas. These are dinosaur slippers for kids. Sounds cute, and when you walk down the stairs, they sound like a dinosaur. But what parent wants a 2-year-old waking them up in the middle, you know, Sunday morning, sounding like a dinosaur? So they didn't sell very well. But there was arguably some patent protection on this and copyright protection on the appearance. This type of thing was copyrightable. What other goodies do we bring? Oh, you know, inventions can be pretty simple. This is one I got early in my career. It's nothing but a grill scraper. But what was unique, it has these different size gaps here, so depending on the size of the bars in your grill, it'll accommodate it. So it comes time to clean the grill. So, you know, patents can be, you know, complex to computer systems or very simple stuff. Next. Okay, so what I'm going to talk about is what is a patent? How do you get one? What are the legal requirements? Who owns it? What is infringement? And how can you avoid infringement? And the last point is as important as the first point, because it doesn't do you any good to get a patent on a product and find out you're infringing somebody else's patent. An example would be Thomas Edison invented the light bulb, and let's say you came up with the frosted light bulb. Patentable, but you can't sell the frosted light bulb because Edison's patent would dominate you. So you know, not only have to look at the ability to protect your market, but can you get into the market without infringing somebody else's product? And when you're working with overseas companies, that's an important question to be answered. Okay, so next slide. What is a patent? Oh, well, here's another product, I guess. This is, you ladies may be familiar with it, an InStyler. It's a hair straightening design device. We've patented this around the world for our client and have sued multiple people, and are getting ready to sue next week another company that's infringing the patent. Okay, let's move on. Next slide. Okay, why seek a patent? One reason is defensive. It establishes prior art, so other people can't get a patent on your idea. Once you file your patent application, it gets published, and it establishes a document that somebody else can't patent what you did. So that serves a defensive purpose. And let's see, we represent Southern California Edison, the major utility, and they come up with new technology, and they're not really interested in suing anybody on it. I mean, you know, they have their own market. Other utilities have their market. You're not going to, you know, Edison can't expand to San Diego or San Francisco. They have a market, so, but they don't want anybody else to get a patent to keep them from using what they develop, so we'll file a patent application, get it published, and not worry about getting a patent. Serves a defensive purpose. Offensive, the patent gives you the right to keep others from making, using, selling, importing the invention, so it provides exclusive rights. It protects market share. Generally, patented products have a higher profit margin than non-patented products. It's a licensing vehicle for you know, little companies that are starting up. they may not be able to take care of the entire market for their product. So with a patent, they can license somebody else to maybe take care of northeastern United States while they maintain the California market. If you file a patent application, you're entitled to put patent pending on the product, even if you don't get a patent. That serves a deterrent effect. People were going to think, should I really try to knock off a product that's patent pending, because if I invest in the tooling and the dies and the marketing and then they get a patent, then I got to shut down. So it does, it at least slows down the competition. Marketing benefits. Salesmen would like to be able to go out and say, you really want to buy our product, we have a patent on it, nobody else can do it. So there's the prestige associated with it. Apple is well known for having lots of patents, and same with IBM. It adds to the mystique in the value of the company. And the last is somewhat important for some people, ego. I've had people come in and say, get me a patent on this, and I'm thinking, this is really a dumb idea. I mean, I can get a patent because nobody's ever done it before, because it's a dumb idea. And I politely say, are you sure you're going to make any profit on this or anything? And they respond, I don't care. I just want to have a patent, and I want to put it up behind my desk, and I want people to think I'm smart. I said, okay. But that's something that we need to be aware of. Next slide, please.
By the way, since this may be new material to you, so if at any time you want to ask questions, you can stop us and ask questions.
Yeah, thank you for mentioning that. Okay, what are the legal requirements for a patent? First, you need statutory subject matter. It's got to be the right stuff. What do I mean by that? It's got to be article of manufacture, composition of matter, a method for doing things, a system. What around this room has probably been patented? Well, I guess that's a copier. Tons of patents. My little microphone here, I guarantee you there's at least 1,000 patents relating to the iPad and the computers in here. So those are the type of things that can be covered by a utility patent. I'm going to talk about that first. So it's got to be the right subject matter. Certain things aren't patentable, like laws of nature. You can't patent magnetism, for example. You can't nowadays patent naturally occurring materials like DNA. You can't get patents on human beings. So there's certain things that can't be patented. The copyrightable material, like songs, that's copyrights. And people confuse sometimes copyrights and trademarks and patents. Trademarks would be like Xerox, the name of the product, but the patents would cover the machine itself, not the name. For a utility patent, it has to be useful and operable. Now you say, whoever comes up with an invention that's not useful? Well, sometimes people think they invented what I call a perpetual motion machine, where you get more energy out than you put in. And again, I try to be polite and not tell them you're an idiot, you don't understand the second law of thermodynamics, that's impossible. I say, you know what, patent office is going to question this. You're going to need to prove it works. Why don't you go do some tests? When you get the tests from a testing lab done, then we'll go file the patent application. Another example, if 100 years ago you came in and said to a patent attorney, I want to get a patent on curing cancer or curing baldness, at that point they would have said, you got to be kidding, nobody can do that. Well, nowadays we can do that. So what's useful and operable changes with times as technology develops. The inventorship has to be correct under U.S. law. Only the inventors can file for a patent the inventors or their assignee can file for a patent application. So if you go down, if you're in Germany and you see a better potato peeler, Germans love potatoes, so you can't come here in the United States and patent it because you didn't invent it. It has to be the person who invented it. And so we always need to look at who is the inventor and accurately determine that.
I want to ask if, say, there is a family recipe, secretive. It's like grandma to invent, but she passed away. So is her descendants be correct inventorship or patentable?
They could be the owner, but they wouldn't be the inventor. She would be the inventor.
So she can't file the,
you can't, as their descendants, you can file. You can file the patent application in her name, and the descendants would own it. So she is the inventor, but her descendants or heirs, whoever owns her property, can file the patent application as the owners, but her name would be on it as the inventor, deceased.
But is something like a recipe patentable? I mean, does it have to be something that's tangible or not necessarily?
Sure, it is.
Yeah.
I mean, chemical compositions are patentable. A recipe is nothing more than a chemical composition. I wouldn't be surprised if there were patents on the Twinkie. Now, a family secret that's been used, I would have told you 2-3 years ago, once you had used it and started making product, let's say you used it commercially. Let's say, a better, recipe for making spaghetti sauce. And you started selling it, but you never told anybody what the spaghetti sauce was, and they couldn't figure it out. After doing that for a year, you could not get a patent because you commercially used it. The laws changed, and possibly, it may even be possible for Coca-Cola to patent their formula for making Coca-Cola, even though it's been out for a long time, because of the recent change in the law. We don't know yet. The law's kind of murky on that issue. So you didn't intend to raise that issue, but it came up. Okay, next requirement. So we talked about statutory subject matter. The invention's got to work. You don't actually have to build it, but it's got to work. You got to have correct inventorship. It's got to be new, novel. Nobody has ever done the same thing before and made it available to the public. So that means nobody else has filed a patent application on it that was published. Nobody else has put it on sale. Nobody's described it in a learned article. You can't find it in a dictionary. You can't find it online, on the internet. It's new. No statutory bar. Well, the way, under the U.S. law now, there's a grace period for where the inventor can put the invention out there for up to a year. But if it's been more than a year, we don't recommend you rely on that, because the United States is first to file now. It's first one to file in the patent office. So we encourage everybody to get to the patent office as quickly as possible. But there's a narrow exception for an inventor who makes his invention publicly known. He's got a year to get the application on file. If you're beyond a year, it's a statutory bar. And the last requirement is the non-obviousness one. And best way to understand that is a specific example from a Supreme Court case. Way back when, in the early 1800s, late 1700s, doorknobs were made out of wood. And somebody came up with the idea of let's make them out of porcelain or clay, some other material. And they got a patent on that because it was better than wood. You wouldn't get splinters in your hand. The Supreme Court said, no, one substitution of a material for another, that's well within the skill of the art. Anybody could do that. So from that, we've developed a test. Is the invention unobvious to a person of ordinary skill in the art? And I recognize it's a murky test, but that's the legal standard, and that's where the fight often is in trying to get a patent in the patent office or fighting for the validity of a patent in the courts. So those are the legal requirements for a patent. Any questions on those? Is that fairly clear? So, yeah, sure.
Can you briefly tell us what are the difference between, because we are new to the industry,
Yeah.
What is the difference between trademark, patent, and
Sure.
IP?
Okay, that's fine. That's good. Let's imagine, let's pick out something. That's an iPad, right? Okay, may I borrow it? Okay, an iPad. What's the trade name of this product? iPad. That's a trademark. So nobody can make a competitive product and call it an iPad. They can call it a Galaxy, but they can't call it an iPad. That's what the trademark protects. Okay, in here is some software. Software, and Dan's going to talk more about that, is copyrightable. It's like, it's text. You and I can't read it, but it's in there. It's like a movie script. That's protected by the copyright law. So anybody can make one of these and not call it an iPad and has to write their own software. They can't copy this software. So copyright protection will cover this thing, and movies, and websites, and written materials, and music. That's what copyright covers.
Website?
Sure, website. You got pictures on there, you got text on there, that's copyright. Websites are copyright protection.
Can it be licensed? Copyright, can it be licensed?
Sure, all of these can be licensed. Everything can be licensed. That's, anybody ever see the movie Gone with the Wind? Based on the book. There was a license from the author of the book, or the owner of the copyright in the book, to whoever made the movie. So now we've discussed trademarks, like Bank of America is a trademark. The official name of this organization is what I call service mark. People can't use your name, but they can't use your printed materials under the copyright. Patents, the type of patent we've talked about so far is a utility patent, and it covers how things work. So based on the utility patent, let's assume the swipe feature on the iPad or iPhone. You swipe, you get a new screen. Let's say, I'm sure somebody got a patent on that, or tried to anyway. If that's the case, somebody can make this product and call it a Galaxy, use different software, but can't use the swipe feature, because that's a functional thing. It's a useful thing. Another type of patent, and that's played a big part in the iPhone versus Apple versus Samsung case, is what we call design patents. And I think I get to that a little bit later, but they cover the appearance of useful articles. Like, a chair is a chair, but this chair has somewhat of a unique appearance with this mesh back. You can get a design patent covering the appearance of that. You can get a design patent covering the hubcap. So there's probably design patents on this, but with regard to the iPhone, here we go again. Samsung can call it a Galaxy, can use different software, can not use the swipe feature, and has to make their product look different. And that's where they ran into trouble in the first lawsuit. That's the big damages were awarded, if any, on the design patent. Did that explain it?
Yeah.
There's one other type, trade secrets, which is like customer lists, methods, the recipe we talked about, that's protectable too.
So trade secret is part of the patent or no?
No. If you get a patent, anything described in the patent is no longer a trade secret. But you can have overlapping. Like, let's say I was making a gun. Okay, I got a patent on the gun, but in making the gun, there's certain tolerances which are important, which don't need to be in the patent. So those tolerances, that this part has to be, within 0.001 inch, and this part has to be within 0.005 inches, and to work together, those could be trade secrets. And there was actually a case dealing with that.
Okay, the reason I pass out the bags early is because in there you'll find a book by Jeff Sheldon, pages 46. It's a summary and comparison of all the IP items. Patents, trademarks, copyrights, trade secrets. It's really handy.
Yeah, if you have trouble sleeping at night, I recommend reading this book.
How long would it take for a patent to be like?
To actually get a patent issued? You're going to get a typical attorney answer. It depends. We've been able to get patents, if you go through, there's expedited procedures available. Using the expedited procedures available, we've been able to get patents in as little as 3 months. And typically within a year using the expedited procedures. If you don't use an expedited procedure and the invention relates to an area where the patent office is backed up, like they're backed up in software right now. It takes them a while to get to it. It could be 4 to 6 years. So
when people file a patent, they file in the U.S. Is that valid also in Europe?
No.
China and elsewhere, or do they have to file the patent everywhere?
Because international, something that they can file at the same time, right?
I know, it gets complicated again. To answer the first question, patents are national. So a U.S. patent only covers sales in the United States, making in the United States, importing in the United States. So if you make it in the United States and export it to Europe, the U.S. patent covers that because it was made here. If you make it in Europe and bring it into the United States, the U.S. patent covers that because it's a sale in the United States and it's used in the United States. If you make it in China and sell it in Europe, the U.S. patent is irrelevant. So patents are national, country by country. So if you want patents outside the United States, then it's necessary to file outside the United States. A typical scenario is you file in the United States, and then as long as you file your foreign applications within a year of your original U.S. filing date, there's a fiction that you filed in that country on the same day you filed in the United States. And it's a treaty. So if somebody in Hong Kong files in Hong Kong and then files in the United States within a year, then they get the filing date in the United States as if they filed on the date they filed in Hong Kong. And that's important because prior art, which can defeat a patent, is determined as of the filing date. It gets even more complicated in that Taiwan is not part of this international convention that gives you a year grace period. So in Taiwan, you need to file quickly. And another, it's not a complication, there's an international treaty called the Patent Cooperation Treaty, which basically lets you defer that 1 year further out by taking, consider it an option. You buy an option. And you get a search and report, and then you can decide. So a lot of companies do that to defer. The foreign filing gets really expensive, and it defers the cost until you're sure you got something worth filing on. So you file in the United States, and then within a year you buy your option, and then about a year and a half after that you spend the big money if the invention's worth it. Okay, well, we know we're throwing a lot at you. Here's an invention. Here's an example of something that isn't novel. Our guy invented the wheel, but unfortunately, his fellow caveman already had the roller skates. So the wheel is not novel. Okay. So how do you get a patent? Optionally, not legally required, is to do a search. Patent applications can be somewhat expensive. There's no use trying to patent something that you can't get a patent on because somebody's already done the same thing or something similar. So we recommend that a patentability search be done. We hire other people to do that. They're usually ex-examiners from the U.S. Patent Office. They'll go through the files, the records that are available from the U.S. Patent Office, come up with some references, and then we'll analyze them and tell you what your chances are of getting a patent. So we do a search. If the results are favorable, then you file a patent application. It's basically a petition to the U.S. government, it's actually the Patent Office, which is part of the Department of Commerce, and basically the petition says, please, please, please give me a patent. We recommend you file early, and particularly U.S. is first to file now. So if you invented it a year ago, somebody invented it yesterday, they filed today, you filed tomorrow, they win, even though you invented it first. It's first to file. There's something weird about, I don't know, weird, it's counterintuitive with regard to the Patent Office. Imagine that with the IRS, whenever you took a questionable tax deduction, like, that dog isn't really a kid, you had to tell the IRS this is a questionable tax deduction. Well, people don't do that. Patent Office is different. If there's any reason why an examiner might not give you a patent, you have a duty to tell the Patent Office that. So when we do a search, we will turn over those search results, not our opinion, but the actual references to the Patent Office to make sure that we comply with this duty. The inventor has the duty, we have the duty. So it's sort of like, please give me a patent, but by the way, here's reasons you shouldn't. But that's the way it works. Prosecution. No, we don't put the examiners in jail, although sometimes I wish we could. That's the term for the back and forth, because more often than not, when you ask for a patent, the Patent Office has problems and they'll say no. And I'd say, what do we get? Patents about 70–80% of the time when we file. If we do a search, our statistics are pretty high. The overall statistics are probably around 50%, 55% on applications issuing. We do better than that if we do a search. But even no matter what, the Patent Office, I'd say 90% of the time is going to have a problem with the application. And so we have to put on our attorney hat and argue with the Patent Office. and that's prosecution. And then U.S. and most, if not all, foreign countries on utility patents have maintenance fees. So if you want to keep the patent in force, you got to pay X amount of dollars at 3.5 years, then again at 7, and then 12. It's to get patents that don't have economic value off the books, and it's a way for the patent office to raise money so that it can keep the cost of getting a patent down. So basically, once you get a patent, you're subsidizing the new applications. Next slide, please. Who owns the patent? The typical situation, the way it should be, is there's a written agreement, and I'm going to jump right to that, between an employee and the employer that basically says, I own it. And under California law, the employer can require the employee to assign any invention the employee comes up with during the term of the employment, with the following exception. If the employee does it on his or her own time, using his or her own resources, and it's not related to the employer's current or reasonably future business, the employee can own it. So if you're working for Boeing and you come up with a better method of making hot dogs on your own time, Boeing's not going to own that. So written agreements is usually controls. There should be a written agreement. In the absence of a written agreement, if the employee would own it under the scenario I just gave you, if the employee was hired to do that, hired to invent, then the employer would own it. If the employee used the resources of the employer but wasn't hired to invent, they're not in research and development, then the employer gets what we call a shop right. Gets to use the invention, but the employee owns it. A potential problem is co-inventorship. Under U.S. law, if you have two independent inventors, each is allowed to practice what's in the patent invention without sharing revenues. So if I got inventor A and inventor B, and inventor A, patent issues inventor A and licenses Apple for $5 million to use the patent, does not have to share that with inventor B. So when there's joint inventorship, it's important that be a written agreement dealing with that sharing arrangement. Otherwise, you got one, the other inventor say, hey, tell you what, Apple, I'll do it for $4 million. The other guy says $3 million, $2 million. Well, you're better off, each getting $2.5 million.
Can you briefly, do you understand now, because we have been working with a lot of university technology transfer office, and some of the universities tell us that they own the patent, but some are not. So is that fall into any category of the categories that you said, like the written agreement, because they are not employee-employer relationship, it's like a school and a student?
Well, that's an interesting issue. You got to look at the agreement. And if you're dealing with a university, do you own it or do you not own it? Sometimes, there's a student manual. And what does the student manual say? Does the student get to keep the invention, or does the student get royalties? A typical scenario with the professors is the university owns it, but they'll get a percentage of the revenues. But if you're before you even send money to the university to do research or do joint ventures or anything, that needs to be clarified in the beginning. There's the universities will say, yeah, please send us the money for research, and we'll give you the first chance to license back what you paid for. Well, that's not such a good deal.
Also, some question, if that is the case, who is going to file the patent?
Well, that's...
You said the inventor, right? You're supposed to be the inventor to go to the patent.
Well, the inventor has to... No. The inventor the application is filed in the name of the inventor, but that isn't the same as ownership.
All right.
So if an employee of Boeing invents something, Boeing's going to, if they want a patent, is going to pay for it. They're going to pay the attorneys and the patent office fees, but the inventor's name will appear on the patent. And then right underneath that it'll say assignee Boeing, which means Boeing's the owner. It's patents like a piece of real estate. The guy who built it, if he sells it, doesn't necessarily own it. It's like your contractor. He's building, you got an architect and contractor, but they're all working for you. You own it. And then it's a piece of property, like you can sell it. The guy who built it can sell it, like you can with a patent, or can rent it out, which is like a license. So, just draw the analogy. A patent is, although it's not real, it's intangible, it's still treated like property. Okay, what's infringement? Basically, I sort of discussed that. A patent gives you the right to keep others from making, using, selling, offering for sale, or importing the patent invention in the United States. So if somebody does that without authorization, without the permission of the patent owner, they're an infringer. That's pretty straightforward. Next, push a button for me. Okay. How do you avoid infringement? If you're copying a product, take a look and see if it's patented. Is there a notice? Is there patent numbers on the product? Or another option now people can do is they can say put on the product, go to our website and see what patents we have. So are there any patents on the product? It doesn't mean there isn't, but often the patent number will be there. If the product doesn't have patent numbers, you can do a search. You can do a search by the assignee. If you're copying a product, put out by Procter & Gamble, for example, you can do a search and see what patents Procter & Gamble has, although you're going to turn out with a real big number. Or you can search by subject matter. Two places that you can search at are the Patent Office website, uspto.gov. I like free patents online. It's free to search. Google now has a patent search function, so you can put in Google patents and that'll show up. You can search by the inventor if you happen to know the inventor who's in this area that's doing stuff. And another way to do it is just have a search done by a professional searcher. Are there any patents? Next slide. Okay, how do you avoid infringement? So we do a multiple step study. And the first step is we go back to the same searcher that's doing patentability, but this is a different question. Patentability you don't spend that much money on, because the question is, should I file a patent application? And infringement search you spend more money on, because if you miss something, the downside's significant. You could invest in a product and can't sell it. You can get sued for patent infringement and know a lot of damages. So we have a search done by a professional searcher. They'll come back with a stack of patents, and we will review them. We'll look at them. What do these patents cover? And we'll sit down with the client and say, okay, here's, and here we came up with 50 patents. 40 of them we're not worried about. 5 we don't think is a problem. Here's 5 more that could be a problem. And we'll say, okay, are you going to do this? Are you going to do that? And then we start moving them to the side and say, oh, well, you're not doing that. We're not going to worry about it. And hopefully, you don't have any problems, but then you may come up with 2 or 3 that are a problem. And you say, well, if you do this, if you change your product by this, you don't infringe. Like right now I'm dealing with a case where it involves elevator hoistways and elevators, and our client did a design around. They eliminated a feature that's in the patent and they don't have an infringement. At least that's our position. Sometimes sometimes these searches will pick up published applications. They're not patents yet, so you don't really worry about them, but they may issue as patents that are a problem. So you follow their progress through the patent office. You'll see if a patent issues and is it a problem. And sometimes you come up with a patent you can't design around. You will infringe if you go in the marketplace. Then we can conduct what's called a validity study. The patent office, I'd say a significant percentage of the patents they issue should not have issued in the first place. Not because sometimes the examiners just blew it, simple as that. Other times, the examiners did not have the best prior art in front of them. We got some patents issued, and we sued somebody in Korea based on them, and they came up with a piece of prior art that we didn't have in the U.S. Patent Office, and that affected the validity of some of the claims we got. So, you can't expect the examiner to make a decision on something that's not available. So that's how you know, if you're counseling people that want to sell a product here in the United States, an important thing is to make sure you're not infringing any patents before you invest in it. And this is the procedure we use. Design patents. I mentioned them already. I sort of got ahead of myself. But you didn't? Yeah. Is it useful? What does that do? Nah.
Culture.
Yeah, okay. Here we go. You can get design patents on packaging. I don't think we did on this. I think it's a conventional design. But the Coca-Cola bottle or the Mogen-David bottle could have been subject to design patents. I mentioned chairs. The automobile companies love to get design patents on their bumpers. That way you have to buy the bumper from them when you get in a car accident. You can't buy it from an offshore manufacturer at half the price. So that's where design patents come in. And Apple has a lot of design patents on their iPhone. So unlike a utility patent, they cover the appearance of the product. So they do not cover how it works. So as I mentioned, the software and the functionality, that swipe feature would be a utility patent. What the iPad looks like would be a design patent. And they're valuable. They're valuable against knockoffs. You know, if somebody completely knocks off a product, I'd love going after them on design patents because the remedies are really good. Next, here's an example, a pill, pharmaceutical pill. Now you say, why would somebody get a design patent on pharmaceutical pills? There's a well-known, medically proven fact that if a medicine works for somebody, they connect in their mind association of the appearance of that product, whether it be the color or the shape. And if you switch it to a identical medicine chemically, but it doesn't have the same appearance, it's not quite. For some reason, it's not as effective. So if you got a design patent, you charge a higher price. Next. Okay, design patents, the requirements are the same as the utility patent, except instead of being useful, it has to have a decorative appearance. The cost is a lot cheaper. The basic price minimum for a utility patent, provisionals I'm not talking about. You can ask Danton about provisionals. They're about $8,500 for a design patent, around $1,500 to $2,000 to get one on file. They're easier to obtain. They don't last as long. A utility patent lasts 20 years from the filing date. Design patents from 14 years from the issue date. There are no maintenance fees, which is nice. And you avoid infringement the same way as for utility patents. So,
Just curious, is there any architects file design patent for their architecture design?
there's actually copyright protection on buildings now and actually the blueprints. You can get design patent on buildings?
Articles of manufacture or something.
Yeah, I assume you get a design patent article on a building.
Buildings are not manufactured.
I don't know. I know people have gotten design patents on water fountains, including the way the water looks. So buildings, I don't know.
Like the Disney Hall, like in China, they built, the Eiffel Tower everywhere.
Well, the Eiffel Tower is expired. I mean, to the extent it was ever protectable, same with the Statue of Liberty, that's coming on.
House or something.
Yeah, that's come and gone too. I mean, that's the thing about buildings. I mean, they last a long time, and design patents don't last very long. So I would. Dan thinks no. I would think yes, because if you can do fountains, why couldn't you do buildings? I don't know. I don't know if I have any more on patents. Are we done? You want to cover? Okay, this is international design registration. So, if you have any questions on the patents, now's the time to ask them because I'm going to be. Well, you can ask Danton, but if you want to ask me something, I'm going to be gone. Yeah, I need to. Okay.
Say a Hong Kong or China manufacturer,
Yeah.
they want to, as you said, they want to sell their products in the U.S. So let's say it's a toy.
Right.
So what are the procedures? So they need to find an attorney to check the patent on similar
Well,
products or some, what's the procedure?
If they have something patentable, typically you'll file your initial patent application in China and then get a U.S. attorney to help you get to U.S. The problem, how do I say this politely? The quality of the patent applications we see coming out of China aren't particularly good by U.S. standards. So they create problems in trying to get a U.S. patent. They're not written to U.S. standards. But that's one half of it, protecting it. The other half is, yes, before they sell it in the United States, they should make sure there's no infringement problem. And I mean, we had, do you have the little cars here? Is this the one we did? Yeah,
No, that's not what we did. That's the 30th anniversary.
Oh, that's okay. We did. We had a situation where we represented a U.S. company that had these model cars, and somebody knocked them off. Basically, it was manufactured in China, and they were selling it through Costco. They did a radio-controlled version of our model cars, and we sued them. So that wasn't a utility patent issue, that was a copyright issue, but still, same problem, same issue. Any other questions? You want to take a break, or are you going to just go?
You get.
For saving time, maybe we go back, because you said you are leaving, so it's just it's very, very small souvenir.
Oh, I love souvenirs. Well, thank you very
I
much.
don't know whether it's patent. No, I'm sure not. But it's just this is like just the new building of Hong Kong government. I'm not whether it's design or design patent, but
It's copyright.
it's copyright. Yes, hopefully it will be.
Oh, very nice. Thank you.
much. Thank you so much, Sheldon.
Well, my pleasure. I've taught in law school. I love teaching, so I appreciate the opportunity.